Yes, Your Honor. Mr. Tucson we're asking for a bond modification to his PR bond. If the court could release his $100 back to him because he's currently homeless, standing in a shelter right now, does not live here. He lives in Alabama. Right now, we don't consider him a threat to society. These charges are 4 years old, and he showed up today. He's not on the tether, so that shows that he will continue to show up for court. Oh, and and he came from Alabama to turn himself in as well.
You did?
Yes, Your Honor. And what it was when I think I was in front of you, you wanted to give me a PR, but I said
I wouldn't.
$100 bond because I don't want to miss my court date. So I ended up reprimanded to the county over the weekend.
That doesn't sound like something I do.
Or maybe it was the other.
I probably was somebody else.
I knew I had to see you.
I'll set his bond at a $5,000 personal cognizance in order that the bond that was posted be returned to the defendant. Yeah, if you don't show up, I know my way around Alabama. I'll come and find you. Hear me?
I hear you, Your Honor.
Oh,
See. All right, sir.
Yes.
Mr. Nelly Thomas, can you tell the judge your name, sir?
Warner Victor Ali Thomas.
In this matter, I have a plea form that indicates that the defendant would be pleading no contest to the charge of attempted resisting and obstructing a first responder, police officer, first responder, that he would be pleading no contest to that charge, a 1-year offense. Upon his successful plea to that charge, counts 1 through 3 in this case would be dismissed. 15th District Court Case 260034, which is a trespassing case, would also be dismissed. 15th District Court Case 260048 SM would be dismissed. And count 2, 15th District Court Case 260033 would be dismissed. The defendant is also agreeing to plead to attempted resisting and obstructing in that 15th District Court case of 260033 SM. He agrees to pay restitution to be determined for all dismissed counts from the cases referenced in this document. There is also an agreement of a sentencing agreement that he will be sentenced to probation. That's the court's full understanding of his agreement.
And that is correct, Your Honor.
That is correct.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name for the record. Warner Victor Ali Thomas.
Sir, it is this court's understanding that you are going to be pleading no contest to the charge of attempted resisting and obstructing a police officer or first responder. Is that correct?
Yes.
That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? You understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Garwood in the 15th District Court.
Yes.
Basis for the no contest plea?
Lack of memory, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind. You signed an advice of rights form or had one signed on your behalf. Any questions regarding any of those rights? You understand that you're giving up all of those rights, the rights contained under paragraph 5. You'll see a copy on the podium.
Yes.
Search our rights. You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
Yes.
Court has been handed and has reviewed Ann Arbor Police Department report for their case number 26888 1877. Any objection to the court reviewing that report?
None from the defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Sir, I do have to apprise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None known to the defense, Your Honor.
And have I complied with the court?
You have, Your Honor.
Court will accept the defendant's plea of no contest to count 4. Counts 1 through 3 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
April 28th at 9 a.m.
April 28, 2026, 9 a.m. before Judge Garwood.
Thank you, Your Honor. And I did want to address bond if possible.
Uh-huh.
Thank you, Your Honor. Mr. Ellie Thomas is currently being held on a $100 10% bond in this matter. I believe that was set as a nominal bond arising out of it being held in the 3-3 matter in the 15th District Court, which is to be dismissed as a result of the agreement made today. He does have housing he would be able to return to upon release, he tells me. And he additionally would like to begin looking for work. So for those of you that are trying to reduction to a personal recognizance bond.
Any response?
If we held on cases hasn't been dismissed yet, it's not something else. It's the court's discretion.
When is that case up?
It's already had
I can check, Your Honor.
court with her yesterday. So this,
What did they give you a new date?
yeah, it'll be Wednesday. I'll be seeing
This Wednesday.
I'll be seeing for the PSI.
He indicates this Wednesday, Your Honor, but I can double check that.
Wednesday? Well, what I'm gonna do, it's gonna be Wednesday. Sentencing to the 28th. I'll grant it. He's not gonna get out at this point, but I'll set his bond to a $5,000 personal recognizance.
Thank you, Your Honor.
Record. He's up on the 15th on the RNO, but that case is not being dismissed. I think that's the case he's pleading to count on. That case will still be pending. I mean,
Right, but that's before Judge Garwood, right?
Correct.
So she'll be able to make a determination, but this won't be in the way because this one's not going to get before until the 28th. That's why we met.
Thank you, Your Honor.
Court calls case People versus Michael Moore.
morning, Your Honor, Raymond Cook, the people.
He in Zoom or is he here?
I'm sorry, he's here.
Okay. Do they have him?
God bless you.
You don't have him. You got him or? Okay.
Yeah, and I do have a paperwork for pre-assigned. I was unable to get this in prior to this morning.
Let's just do this now. Why am I just getting it? It's not your fault. Don't worry about it. You're good. Bukovich? Whose fault is it that I'm just getting this?
To Mr. Bukovich's credit, he really did wear me down this morning. So
Yes.
Why are you trying to save everybody? Everybody, you know what? Fine.
And I wasn't going to throw anyone under the bus. So
You will when those tired threads go over you. But all right. So what I have here is I have a plea form that indicates that the defendant will be pleading guilty to 2 charges, which is the stated count 2 of domestic violence, the 93-day offense, and to count 5 of attempted resisting and obstructing the 1-year offense. Upon a successful plea to counts 2 and 5, counts 1, 3, and 4 would be dismissed. The defendant is agreeing to continue mental health treatment as recommended by his mental health professionals. There is also an agreement between prosecutor and defendant prosecutor will recommend the DV plea placed under 7694A. And that the attempted resisting and obstruction be a prosecutor's deferred sentence. That's the court's full understanding.
That's correct, Your Honor.
That's correct, Your Honor.
May I have the defendant sworn?
Right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Lower your hand. State your first and last name for the record, please.
Nicholas Harding.
All right, sir, it is this court's understanding that you're going to plead to 2 misdemeanor charges. Is that your understanding?
That's correct.
First of all, this court's understanding you're going to plead to the charge of domestic violence. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. Do you understand that?
I do.
All right. And also that you're going to plead to an added count 5 of attempted resisting and obstructing a police officer or first responder. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court cost. You understand that?
I understand.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, I understand.
Still wish to plead guilty?
I do.
To the charge of domestic violence, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes,
You signed an advice of rights form?
I did.
Any question regarding those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
Probation.
All right. Were you on probation at the time of this offense? All right. You understand that your entry of a plea in this case could be a violation of that probation. You understand that as such, that court could sentence you to the maximum allowable under those other charges. And understanding that, do you still wish to plead guilty to these charges?
I do.
Has anybody promised you anything other than what's been stated here today to get?
No, Your Honor.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily
I am.
of your own free will. And because you believe that you are indeed guilty of these offenses?
Yes.
On the date of November 4th, 2025, at the location of 1501 Briarwood Circle, City of Ann Arbor, Washtenaw County, State of Michigan, what'd you do involving a Joe Y. Kwan that makes you think that you're guilty?
I made a threat while under I made a pretty alarming threat to the individual under question.
All right. And this individual, and it would cause them to have fear that you would do something.
I'm sorry.
It would cause you to.
Them to believe that you would do something to them.
Yes.
Is that correct?
Yes.
All right. And this individual you had a dating relationship with?
Yes,
All right. And did the police arrive at some point?
they did.
All right. And so you came into contact with Ann Arbor Police?
Mm-hmm.
Yes?
Yes.
Okay. And what happened?
It was under my assumption we were asked to leave the property and
Leave
Mm,
Howard Cooper?
I'm sorry.
You were asked to leave the property.
Yep.
Okay.
And after some time, I was not well mentally at
Right.
that moment.
But what happened with the police?
Um,
When they were trying to take you into custody after you were arrested, did you attempt to pull away from the police
Yes,
officers?
I did.
Okay. So you knew that they were trying to arrest you and you attempted to pull away,
Pull away.
Or move away from
Yeah.
obstruct what they were trying to do.
Mhm.
All right. Sir, I do have to advise you that if between the time I accept your plea and the time of your sentence, you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. Understand?
I understand.
All right, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Sorry, thank you.
No, Your Honor.
And have I complied with the court?
If we're satisfied, Your Honor.
The defense is satisfied, Your Honor.
Court will accept the defendant's plea to counts 2 and 5. Counts 1, 3, and 4 are dismissed. Pre-sentence investigation and report is ordered at 15th court probation. Sentencing will be
April 29th at 8:30.
April 29, 2026, 8:30. That's before Judge Perry. Bond with its conditions will continue.
As you may address one bond condition, Your Honor.
One,
Yes.
issue a bond
Yes.
after you give me sheets late and everything? Sure, go ahead, Buckovich.
Your Honor, my client would be asking for the consideration of removal of the tether. He has been on that tether since November without any other issues. He has been doing great work as it relates to his mental health treatment. That was a big consideration on why this offer was extended by the prosecution, the excellent mitigation report written by my mitigation team. So I would just ask for the consideration of the removal of the tether because it is, he has been complying on it since he's been placed on it, and it is producing a financial burden. I do understand if you want to leave that decision for the sentencing judge, and I did discuss that with my client.
Your Honor, Mr. Buckovich is absolutely correct that was something, that how well Mr. Hargan has been doing and during the process of this case is definitely something that we considered when making this offer. Your Honor is more than well aware that Mr. Hargan has come to every proceeding, has been respectful, has done just about everything. I would defer to the court in this decision. I think there is a defendant.
I'll grant the request. And that the tether may be removed. You're welcome.
Thank you.
Oh, you don't have to thank me. I'm talking to. So we'll release it. All right. We'll contact him. And so when you leave here, you can go over there and
To
Community
inspections and give it back to him.
Okay, thank you
All right.
so much.
Tell him Mr. Buckovich said, here, take this thing.
Do I need any?
Yeah, get real nasty with it, okay? No, you don't do that.
The last time I was there, someone was in a similar situation, and do I have to have a piece of like paperwork or?
It's a paper to do it. We're sending it over now.
So the court's sending it over directly.
We're emailing them.
Oh, okay. Thank
All
you.
right.
Okay.
They won't take it off. It's Buckovich's fault.
Okay.
All right.
Thank you.
Have a good day.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, for long granted. Was fine.
It was your fault. I figured as much. What's your name?
Latanya Link.
All right. What are we doing on this?
We would like to set this matter for a preliminary exam,
All discovery is complete.
best of my knowledge.
And would people have their witnesses available the 21st? All right. Preliminary examination will be set April 21st, 2026, 9 a.m. That is in person before Judge Washington.
Thank you, Your Honor.
Bond will continue.
Thank you, Your Honor.
Thanks, Your Honor.
Court calls case, People versus Reginald Tucson.
Okay.
Don't go too far. You.
Ron Strickland on behalf of Mr. Tucson.
Good morning. Morning. Your team.
Reginald Matthew Tucson.
Thank you. What are we doing on this?
Yeah, we would like to adjourn this matter, but we also would like to file when appropriate.
Public cause conference will be adjourned April 30th, 2026, 9 a.m. Esteban.
Yes, Your Honor. Mr. Tucson we're asking for a bond modification to his PR bond. If the court could release his $100 back to him because he's currently homeless, standing in a shelter right now, does not live here. He lives in Alabama. Right now, we don't consider him a threat to society. These charges are 4 years old, and he showed up today. He's not on the tether, so that shows that he will continue to show up for court. Oh, and he came from Alabama to turn himself in as well.
You did?
Yes, Your Honor. And what it was when I think I was in front of you, you wanted to give me a PR, but I said
I wouldn't.
$100 bond because I don't want to miss my court date. So I ended up reprimanded to the county over the weekend.
That doesn't sound like something I do.
Or maybe it was the other.
I probably was somebody else.
I knew I had to see you.
I don't think he He'd have to go downtown Ann Arbor to get the money back.
Yeah.
Know that, if that happens. And he doesn't get 100.
10%. I know.
Yeah, we take our 10%.
I understand, sir.
The biblical thing. What?
No, it took 10%. I didn't know that.
Fees cost.
We don't really take it.
Now, this is one of those unexpected courtroom moments that completely changes the energy in the room. After nearly 20 minutes of legal procedure, plea deals, and serious discussions about bonds and probation, the judge suddenly shifts into humor, and everybody relaxes for a second. But beneath the jokes, there's actually something important happening here. The defense is arguing that this defendant isn't a flight risk. He voluntarily came all the way from Alabama, turned himself in, and even asked for a bond because he wanted accountability. That's the kind of behavior judges often look for when deciding whether someone deserves leniency before trial.
That's kind of harsh.
Right. It's a thing.
Taking
Process.
service fee.
Yes.
Yes, I've been able to come up with it. Yes. All right. Well, what? Otherwise, he doesn't have any money.
Exactly.
No.
Exactly. And this would really help him out.
I usually don't. All right. I'll set his bond at a $5,000 personal cognizance in order that the bond that was posted be returned to the defendant. Yeah, if you don't show up, I know my way around Alabama. I'll come and find you. Hear me?
I hear you, Your Honor.
Oh,
Yeah, but
Ooh. Gee.
no.
All right, sir.
yes.
Before you leave, you'll need to see my staff. Okay, because otherwise, just about how to get your money back.
Okay.
Okay.
No problem.
All right.
May I swear in Miss Maggie?